Introduce the folks who will be bringing the materials to you. The first is Lorenzo Lisi and Megan Cowan, who are active, as I'm sure you all know, in our human rights and workplace law section, as well as Paige Bachman, one of our partners who specializes in privacy. The agenda will be covering the Ontario Human Rights Code, and I just wanted to say I was particularly interested in being invited to moderate this morning because way back in the 80s, I was a member of the Ontario Human Rights Commission at a time when sexual harassment was not covered by the code, and we had to work very hard to bring people up with respect to just simple education. So it's heartening for me some 40 years later to see that, in fact, it's embedded in the law and in the codes and policies. So I'm looking forward to hearing from Lorenzo and Megan in that regard. They will also be speaking to the Occupational Health and Safety Act and addressing the issues you see on the agenda, as well as bringing in the criminal code education with respect to the allegations of criminal acts. And Paige will review aspects of the privacy law, and probably most importantly, the policy and investigation outline will be provided for you. So let me just highlight for you the context. As I'm sure you all know, the Me Too movement spread virally in October of last year as a hashtag on social media to demonstrate the widespread prevalence of sexual assault and harassment, especially in the workplace. Canada, as I'm sure you're aware, is no exception. We've had allegations in TVO, Hydro One, Soul Pepper Theatre. But I think the Me Too movement has highlighted the importance to organizations of ensuring not only that they have appropriate policies with respect to harassment and sexual misconduct, but also a process to effectively address complaints in a manner which is both sensitive and fair. Doing so will allow corporations, institutions, and organizations not only to meet policy directives, but also to assure consumers, customers, and, frankly, investors that they are worthy of that trust. So let's go over, if we could please, to the Ontario Human Rights Code and just ask Lorenzo to start the session.
Thanks very much, Jane. And way back when I had less gray hair and more of it, I also was involved early on back in the 80s and the early 90s. There was a huge issue with respect to sexual harassment and then policies, and there was a case called GM versus Bannister where the issue was that even if you had a policy, if you didn't enforce it, it was worth nothing. And sexual harassment in the workplace kind of dipped in importance for a while, and we started to see a lot more complaints about harassment and accommodation with respect to disability and general harassment claims. That has now reached prominence again. And part of it is because it went underground and companies just kind of internalized it, right? So if you're looking at what the legislative framework is, and that's what we want to talk about, so you understand how this works, the Ontario Human Rights Code is primarily, and we're going to talk about the Occupational Health and Safety Act as well, but it is the framework, the legislative framework that talks about sexual harassment as a prohibited ground of discrimination, all right? And the case law that has evolved from that really does speak to what you can and can't do in the workplace. It applies to all workers and workplaces in Ontario. It doesn't mean that it's okay if it's not under the Human Rights Code. What it means is that from a prohibited ground of discrimination, it is protected, and employees are protected. And it applies to all employees, including supervisors. It sets out what the obligations are under the code for an employer. All right, it prevents all employees from discrimination and harassment of any kind on prohibited grounds. And in particular, what we're going to talk about today, sexual harassment. So how do we get there, right? What are we talking about? Well, let's define this because everybody wants a definition. It doesn't always fit perfect, but everybody wants an easy definition to use. Here's what the courts have said, and there's legal words here. Vexatious comment or conduct that is known or ought reasonably to be known to be unwelcome based on one of the prohibited grounds. What does that mean? Let's forget lawyer speak. When you do something to someone else that disturbs, annoys, or distresses them that you knew or should have known that they don't like. That's boiling it down to its essential elements. All right? Now, there is an objective, right, criteria here. So that is known or ought reasonably to be known. That's an objective criteria. You can't say, I'm just too dumb to have figured this out. If you knew or ought to have known objectively, that's the standard. All right? So let's work with the definition under the code. It's sexual harassment on the basis of any prohibited ground, and that can include sexual orientation, gender identity, or expression. All right? Unwelcome sexual advances and threats or reprisals for the rejection of sexual advances made by a person in a position, very important, to grant or deny a benefit to the employee. So even if the conduct doesn't constitute, and we'll talk about this in a little bit, sexual assault under the criminal code, which is a much higher standard, if you are in a relationship with a subordinate, all right, red flags should be going off. All right, it doesn't matter that it's consensual. From a workplace perspective, it's a problem. So can we take that out of this, staple it to your forehead, and don't forget that, all right, because that's a big deal, all right? So if there are unwelcome sexual advances and threats or reprisals, right, that's a problem. It can be verbal, physical, or visual. That means you can say it, you can do it, or from an objective perspective, you put something or put something up in the workplace which objectively would be offensive. Let's go back again to the standard. Does a reasonable person in the shoes of the victim, would they have been offended? The objective standard. All right? It doesn't have to be intentional. It can just be stupid, and most of the time it is. All right? And it can be a series of comments for a period of time or one incident, which is so egregious that it triggers the obligations under the code in that law. And the victim doesn't always have to object to the behavior to establish that it is harassment. Remember that. Like from an investigation perspective that you may have in your policy that it says you got to tell them that it's stupid and that it's offensive, but that doesn't mean that it always has to trigger that. So get back to it. Comments or conduct that tends to ridicule or disparage a group, causing humiliation, insult, or apprehension, or disruption, may poison the work environment. That's not just sexual harassment, it's all harassment on prohibited grounds of discrimination. And the comment or conduct doesn't have to be directed at a particular person. It's the poisoned work environment. Way back in the 80s, you'll remember, or those people are old enough, remember the Sunshine Girl photos. They were posted in the workplace.
That's right.
Right? And they said, well, I put it up because I thought it was okay. But that creates a poisoned work environment. So, Megan, tell us about examples of sexual harassment.
Sure, thanks, Lorenzo. This is a great slide just highlighting common everyday examples that can happen in the workplace and that are obviously unwelcome. Posting or texting inappropriate material to an employee, sending sexual emails, texts, or photographs. You'd be surprised how often these types of issues come up for us as employment lawyers. But, even just making an off-the-cuff, casual sexual remark or comment that could make someone else feel uncomfortable, touching another employee in a way that it's not welcome or that makes him or her feel uncomfortable, asking another employee for something sexual or romantic in return for a benefit of some kind, or threatening an employee if they don't respond to sexual advances. Now, under the Ontario Human Rights Code, employers have an obligation to maintain a harassment and discrimination-free environment. So they must be, they must ensure that they have policies in place, that employees are trained and understand their obligations. And remember, especially, that a corporation can be held liable for the actions of its officers, employees, or agents. So oftentimes we see applications to the Human Rights Tribunal where both the employer is named and an actual employee is also named. However, in the case under the code, it's really the employer that all liability stops with. So it's important to remember that. Now, harassment and especially sexual harassment in the workplace can happen anywhere. If we go to the next slide, it's not just the four corners of the workplace anymore. It can take place outside of the workplace in something that's connected to it. So, for example, off-site meetings, business trips, social gatherings, recruitment lunches, dinners with potential candidates, end-of-year parties, especially with
company Christmas party.
Yeah, exactly. I was going to say where alcohol is served.
Developers conference.
Absolutely.
So, any conduct at any of these types of events can lead to claims of harassment. It's not just the four square corners of the workplace anymore.
And if I could jump in, it's Paige speaking. I'll bring the technology online environment in addition to the privacy environment. Don't think because you go home and you post something on Facebook after hours that it's out of reach. Absolutely, those are, they can be considered sexual harassment in the workforce depending on the context. And for those of you who think private chats are private, reconsider that, because we always get screenshots sent to us from private chats that end up in litigation or issues for employees.
Very good point.
Now, last point here on the code. Under the code, retaliation, threats, or reprisals in relation to a complaint or proceeding are prohibited. So that essentially grants every person the right to claim and enforce his or her rights under the code without a threat of reprisal for doing so. So this means that if someone alleges that unwelcome conduct occurred, the employer has a duty to look into it and can't take unnecessary or improper action against them, most specifically firing or demotion or anything like that.
And so where does this leave us? So, all right, that's a lot of information to digest. I want everybody to sit back and take a break. Deep breath, all right, and particularly as an employer, this has all come down very quickly. The bottom line is this. It's going to be an issue. We know politically and practically, legislators are looking at this. You've seen the commercials put out by the Ontario Liberal government, and they're very specific about sexual harassment in the workplace and just generally. All right? So I think we can look at this from an occupational health and safety standard perspective, and we're going to talk about that. It's due diligence. Have you provided and can you prove that as an employer you have set up a due diligence process to ensure that complaints are taken seriously, investigated, and that you can prove due diligence in the event of a complaint. And training is a big part of that. But again, if we step back a little bit, and there's a lot of questions that we have about this already, you got to do almost a triage with these complaints. Because I cannot tell you, and I'm not ascribing any improper motives to anybody, I cannot tell you how many complaints we get where there's a harassment complaint just before a performance evaluation, right? Or just after a termination, or just before a termination meeting. And that can say a stress claim. It can come through in the form of a stress claim or a complaint against the manager, right? And then the employer is stuck with, well, what do I do? Because now we were about to terminate. They brought a harassment complaint. We're under an obligation to investigate. What do we do? And that's a cost, benefit, and risk analysis then. It is a business decision, but you've got to make sure you've done the due diligence. And the questions that we have about that is, what do we do in that case? Well, we go through a protocol and a process that is specific, consistent, and actually addresses the issues of possible reprisal. And if you don't have documentation about the performance issues prior to, you're going to be nowhere. So that's why it's very important to create that file if we're moving forward. If you remember one thing about this whole seminar is document, document, document. All right? You have to have a file or you got no case. All right? So all employees are responsible for complying. All right? No one is exempt. Right? It can lead to discipline or termination. Right? It can lead to damages both against the individual and the company. All right? And remember that anybody can access these decisions in a public forum. You can settle them in a private way, which brings up a whole bunch of issues of privilege, but you can't access them. But you can access them, but you can't make sure that nobody can hear about them unless you settle it. If it goes to a tribunal and you have a decision, it's open to everything, to everybody. So, how do we meet the duty? Well, there you go. All right, make sure you've got policies. Make sure you're prompt. The policies are something that you need to review right now. All right, make sure you've got that protocol. We're going to talk about the investigation process later. Really important. Have the resources available. Make sure that there is a protocol and also a way to deal with the fallout from a very, very disruptive complaint. All right, we need to treat the complainant with respect and dignity, but we also need to ensure that everybody is treated with respect and dignity while we undertake that investigation. Because if you don't, you might have the alleged harasser, if you can't prove it, bringing a claim against the company for harassment and damage to their reputation. All right, and we can everybody around this table will know that. And communication plan. How was it communicated? That's part of the obligation under the legislation. And then with respect, we're going to talk a little bit about case law because Megan's going to go through this. But harassment by clients, all right, it's the employer who has the control over this. They have to meet the duty, all right? If they have the duty, even if it's a third party who's at their workplace, they have, just like if you've got a third-party contractor under an occupational health and safety, if they do something which endangers, right, other employees, for example, a maintenance company that comes in and does something improper where employees get hurt, it's the same standard. Look at it that way. Everybody doesn't have a problem with saying you didn't put a guard on a machine, somebody got hurt, you're liable. Why is sexual harassment any different? It's not. Is it harder to prove or disprove? It might be, but if you have a protocol in place, it is going to make your life so much easier. And as much as we know you love to pay our bills, it's going to make your legal bill a lot less. So that's important here. So in deciding if there's reasonable steps to eliminate the problem, they're going to look at whether the employer, and that's a tribunal or a court, took reasonable steps to eliminate the problem, acted promptly and effectively in all the circumstances, and assessed the appropriateness of the efforts to prevent harassment. So, digest that with your breakfast, okay? While you're having your coffee, and Megan's going to talk about a few cases which I think are critically important in understanding the framework of investigation and liability to employers. So, Megan, over to you.
Thanks, Lorenzo. This first one with Hamilton, it's a bit older, but it's a good case. It's in a unionized context. In this case, the employee was the only female inspector working on a transit service line, where the staff was largely male. Her supervisor had a habit of providing her with uninvited massages, so, unwelcome touching, sending her emails containing pornographic content, as well as making inappropriate sexual jokes, comments, and gestures. So you can see here further examples of just some really egregious conduct in the workplace. So the employee in question brought a grievance against her employer, alleging that she was humiliated and was powerless in a poisoned work environment created by her supervisor's sexual harassment. Now, this went to arbitration, and the arbitrator found that the employer had failed to provide the complainant with a reasonable response to her complaints. It didn't matter that some of the emails had been sent through personal computers, and this goes to Paige's earlier point that conduct outside the workplace can still count as workplace conduct, and held that the employer was responsible for the supervisor's sexual harassment and ordered that the employer pay $25,000 in damages for pain and suffering.
So, really good case, and we were sitting around the table this morning prior to this webinar and talking about the obligation of the union as well. So employers don't step back from that. They are under an obligation to ensure that their members don't engage in sexual harassment. And look at this is 2013. It's not 1992, right? It's 2013. Make sure you play some pressure ball with the union to say you're under an obligation too. Would you agree with that, Jane?
I would, and one of the things we commented on is that this is now being bargained for regularly, whereas even a decade ago it was perhaps something new being brought to the bargaining table.
Absolutely, and the law is too that you kind of can't contract out of the obligation. Right? The union is under that obligation as well, and not only that, they can actually do the investigation, but the employee can say, I want to take this outside. I want to file an independent complaint. Now, there can be a deferral of that complaint to the tribunal because the tribunal may say you've got it under the collective agreement, but you can't just say it can only go under the arbitration process. So, really good case, Megan, and something we should talk about. Next case.
Thanks. This is Boucher and Walmart Canada. It's a well-known older case as well, but it really is important to point to because it's such a large damage award that was awarded in this case. Now, Ms. Boucher was an assistant manager at a Walmart, and she worked there for several years. She alleged that her supervisor engaged in a course of harassing and abusive behavior towards her over the course of 6 months. This behavior included forcing her to count skids in front of other employees to prove that she could actually count, calling her, some rude and offensive language, words, and she eventually brought a complaint to Walmart. Now, Walmart is quite a big employer, and as a large employer, it has an open door communication policy and a complaint mechanism. So she went through the company complaint mechanism. And following that, some things happened that do not paint Walmart in a great light. Her request for a meeting with senior management was actually leaked to her supervisor, and he continued his conduct towards her. Now, despite the investigation and review and the fact that several of the employees' team members and colleagues commented about how her supervisor's conduct was so egregious and horrific, Walmart still concluded that her complaints were unsubstantiated, and in fact advised her that she would face discipline for making unsubstantiated complaints. So because of this, Ms. Boucher eventually quit, and she brought a claim against Walmart in court for constructive dismissal, sexual harassment, intentional infliction of mental suffering, and assault. The action went to court and was tried before a judge and jury. And the jury found that Ms. Boucher was constructively dismissed and awarded her the highest award to date in Canada for an employment-related suit. You can see here on the slide just the amount of money at question, but big figures for in this case, a course of conduct that really only lasted under 6 months. But I think you can see from the previous slide that it really, I think, had to deal with Walmart's internal handling of the complaint and the way that it had dealt with it. Now, importantly to note, if we can go back a slide, her supervisor, if you can see at the second last point there, Mr. Pinnock, he was found to be directly liable himself towards the complainant in this case, and the total damage award was in the millions. Now, this was appealed in which the Court of Appeal, and it did reduce the award of damages somewhat. The punitive damage award was reduced, but it still is, one of the leading and largest damage awards in Ontario employment history. So it's an important case to point out, and I think it really highlights, as we've been saying, the importance of having an internal policy and process in place that's followed and documented well.
Yeah, and again, this one takes in kind of the harassment generally, right? And it doesn't have to be specifically sexual, but it all falls under the same rubric, which is harassment at the workplace, which causes damages and can cause mental distress and suffering, which exposes a corporation, a company, even a small employer to damages either before their Human Rights Tribunal, under the Occupational Health and Safety Act, in court, any of those issues. So it's multiple liability. So really what we're talking about is what triggers, what should you do? We always say it's the step that will make somebody in the company stop before they act. How do you show that you have the policies that say, don't do this, stop before you do anything? And this is a really good, because Walmart's a big company. They make lots of money, they employ lots of people. I don't know why they litigated this case, I got to tell you. I don't know why this went to litigation. The facts are awful, all right? Settle the thing. But they did, and it's important. So next one is also really, really important. Megan?
Thanks, Lorenzo. This was a well-publicized case in 2015. It went to the Human Rights Tribunal of Ontario, and it involved 2 temporary foreign workers from Mexico who brought an application against their employer, Prestige Foods Limited. Now, during their employment, the owner of Prestige Foods engaged in a persistent course of conduct that included harassment, sexual solicitation, advances, touching, and sexual assault, both on the workplace and off. Furthermore, the owner would often threaten to send them back to Mexico if they refused to comply with his demands. So the 2 sisters eventually brought an application seeking damages for discrimination under the code, and named, both the employer as well as its owner personally, which we've discussed earlier under the code. Now, the Human Rights Tribunal found that the woman had been subjected to unwanted sexual solicitations and advances, sexual assault and touching, and a sexually poisoned work environment, and were discriminated against on the basis of their sex. both by the conduct of the company, but by the personally named respondent itself. The Human Rights Tribunal awarded a very large damage award of $200,000 to the two sisters, and I think it was partly due to the fact that they were in such a precarious position. There was a huge power imbalance here. There were two temporary foreign workers from a different country under the power and control of this corporation, and the personally named individual respondent. So you can see here again a very large damage award being made at the tribunal, and you can see the fact that corporate respondents can be both jointly and severally liable.
And Prestige Foods in this case was not a mega corporation, right? This is one of those things where at the front end there should have been kind of a triage, an assessment of damages, and given the facts, and I know that most employers say we didn't do anything wrong, but this is something that you might. It's almost like settling a liability case, a medical liability case, where now a lot of hospitals are going and doing this triage with the complainants and trying to get it settled in advance. That would have been a really good case to do that in. And this is 2015. I realize it was the front end of what we're going through now, but it would have been a really good case to do that because you have to accept some responsibility if there is even a potential liability. Would have been a good case to settle. Understand why employers don't want to always settle these things, but if you do the work ahead of time, you're actually in a better position to do that. And one final case right now, Megan Anderson versus Law Health.
Thanks. This is another Human Rights Tribunal of Ontario case. It's again, workplace conduct that was unwelcome. An employer would text an employee to ask her about her weekend plans, asked if she'd go away with him, implied that if she accepted his advances, he would give her financial and professional benefits. She declined her employer's advances, and the employer eventually became hostile and actually refused to pay her, which forced her to resign. The female employee brought a complaint to the Human Rights Tribunal, and it went all the way to a hearing, and the tribunal found the employer's conduct constituted sexual harassment. In reaching this decision, the tribunal considered the power imbalance, and specifically the difference in age between the parties. The gentleman in question was 45 years old. The employee was a 23-year-old female. The tribunal also commented on the employer's conduct and the negative impact it had on the employee. And you can see here the range of damages that it awarded. There's three specific categories. One was just general damages of $22,000 to the employee for injury to her dignity, feelings, and self-respect. But then also, the tribunal awarded unpaid wages for the period of unemployment following her forced resignation. And then finally, it also awarded monies for counseling services, because I'm sure she brought forward evidence of the emotional damage that this had caused her. So important ramifications here from a financial perspective, so that you can see what some of the powers are of the tribunal in its ability to award damages.
And look, if we boil it down, and we'll talk a little bit about the conclusions of these cases, but it expands, and Paige is going to talk about how the workplace can expand and privacy issues, but it can include behavior which, even if it starts consensually, still crosses the line. So I had a client last year where there was a consensual sexual relationship between two people. There were pictures that were sent between them, naked pictures, but one of the individuals actually shared those with other employees, right? And also, other supervisors just viewed them. And they didn't tell anybody in power at the company in a position to make a decision about the fact that this employee was showing these pictures, even though they didn't actually have them or distribute them. And 4 supervisors were terminated as a result of just viewing them without bringing them to the attention of the company. All terminated, nobody brought a claim. All right? So remember, that's a bigger issue than just there was a sexual relationship. That moves to a different level. So any of the prohibited grounds, including sexual harassment, is a problem. There are going to be damages awarded by the code. And I always tell employers this. It's not supposed to be fair. It's not a level playing field. It is remedial legislation. It's supposed to help the person who is in a power imbalance. All right? It's remedial. Not a level playing field. It's not supposed to be. So you're going to be under a higher standard as an employer. Have the right processes in place. And remember this, it can be a single incident, all right? It can be outside the workplace. It can be an ongoing pattern of conduct, and it can justify termination in the circumstances.
Well, thank you, Lorenzo and Megan, for that. A lot to digest and very well put. Now I'd like to move into the Occupational Health and Safety Act, because that also applies. And I'm sure you'll address whether it's an extra layer, whether it's sits beside the code, and how these things work together.
All right, you're all, thank you, Jane. You're all familiar with the Bill 168 stuff that came out, the violence and harassment in the workplace, and more importantly, the obligation to investigate. So when we look at the Occupational Health and Safety Act, we also know that this can include criminal code violations and violations under the civil law, right, under under civil law. So we know Bill 168 came in 2010. The campaign, It's Never Okay, that's the provincial Liberal government, and it really does try to set out the fact that the standard has moved, all right? Workplace harassment is now taken seriously, and you have to have that due diligence in place. So what constitutes harassment and violence under 168? Well, you've seen this definition before, haven't you? We'll go back 20 minutes and we can talk about the definition of a course of vexatious conduct or comment or conduct against a worker in a workplace that is known, and hear those words again, ought reasonably to be known to be unwelcome, the objective standard. It includes sexual harassment. It includes potential violence in the workplace, even threats, all right, reprisals, threats, even if they're couched in normal conduct or behavior, if they're included against an employee, we got a problem. All right? So neither the sexual violence nor the sexual harassment needs to be on any particular grounds to be prohibited. Outside of the Human Rights Code, this is much broader. If it's violence or harassment in the workplace, you treat it like a guard, like a machine doesn't work. What did you do? Did you put the guard up? Did you lock out on an electrical investigation? All of that, it's the same. And what are the employer obligations under this legislation? You remember them well. Under Bill 168, they are workplace assessments, the development of workplace policies which deal with harassment in the workplace. It's the extension of the right to refuse unsafe work, even if that unsafe work constitutes a conduct of sexual harassment. All right? And there's domestic violence in the workplace and the obligation on the employer to investigate where appropriate, and mandatory disclosure of violent history. Where the rubber hits the road is what are the employer's obligations when somebody says, what did you know about that employee's conduct when it came to a violent history? Got to be real careful about this one. That's why you got to take advice if you hear about some violent history from a domestic violence perspective, all right, or general violent history in the workplace. And there are some cases now which address this and have from the beginning. If you want to know where law is going, folks, look to arbitration decisions, because you get those decisions way ahead of the court decisions, right? Because they're immediate, they come through the grievance procedure, and you have arbitrators who interpret the law. So if you want to know where it's going, talk to your friendly labor and employment lawyer. They'll give you what the parameters are, and that's really helpful. And Tenaris is a good example. Megan?
Yes, this is a unionized context case. Some interesting facts. An employee was dismissed for posting derogatory and sexually suggestive comments about a female coworker on his Facebook page. This included the suggestion that a violent and humiliating sexual act be performed on her. At arbitration, the arbitrator found that there was just cause for the termination on the basis that the employee sexually harassed the female coworker and it created a poisoned work environment. Now, sort of to Lorenzo's earlier example, another employee who had actually participated in that Facebook thread also was subject to grievance procedure discipline procedure, and received a 10-day suspension just merely for being part of that online thread and commentary. Now, going back to the Occupational Health and Safety Act, the employer had actually trained the employee just 2 years before on Bill 168, and this fact that the employee knew of his obligations under the Act was found to be an aggravating factor in the case. Aggravating, excuse me.
So if you look at it then, in this case, the employer is still responsible. Mm-hmm. In terms of defending against any discipline against that employee, they have actually evidence that they did their due diligence. It doesn't get the employer off the hook, though.
Yeah.
Right? The employer can say, look, we trained the guy, and it was a guy, so we trained him, and he still did it. And so a court might say, okay, that's fine, but you're still responsible for his conduct.
Yep.
If they terminated him because of it, they got a good just cause explanation for damages against them.
Yep.
So if we look at where we bring this up and how we wrap it on it, Megan, maybe you can tell us a little bit about this.
Sure. I mean, it's the same with what we discussed earlier with the Human Rights Code. Employees are entitled to a workplace that is free from sexual harassment and violence, and employers have a responsibility to ensure that no one is exposed to this type of behavior. So violations of the Occupational Health and Safety Act can lead to substantial damage awards against the employer. And we're going to be talking about this a bit further on in our section on policies and investigations. But under the Occupational Health and Safety Act, employers have a duty to investigate and prepare a written report outlining the findings of the investigation. So we'll be getting to this later on, but that's something to just keep in mind in terms of your obligations under this specific piece of legislation.
Okay, and one more comment just before we move on to the privacy issues. The criminal code. This is a real issue for employers because they could get alleged conduct that might actually cross the line into a charge under the criminal code. And dealing with this at the front end is really problematic. I have a client right now where the investigation is stalking, right? There was a consensual relationship. The female in the relationship and the new boyfriend are alleging that the individual alleged harasser has been stalking them, showing up outside their house, all that kind of stuff. So where does this cross the line? Is there an obligation to report it to the police? Well, I think you got to get advice on this right away, but I think to be safe, you have to do that. But where does that leave you? Because there are different standards. There's a civil standard of the balance of probabilities, and there's a criminal standard beyond reasonable doubt. And the timing is so much different because a criminal charge can go a year before you ever get it resolved or there's a trial. But the original investigation on the civil standard has to be done right away. How do you have them in the workplace? Is there a charge that says that they can't go near this person? How do you manage that? How do you accommodate when they're in the same workplace? Is it too small to make sure that they don't? Do you suspend? If you suspend, is that a constructive dismissal? Like, these are a lot of issues. And actually have, put my kids through university just because they become so problematic for employers that people need advice. But that's where you get advice, folks. That's the best place to get advice. Don't try to do this on your own. And talking about don't doing things on your own, we're going to talk to Paige about privacy law now.
Well, thank you. And I like to think that in privacy, we have some very interesting and unfortunate cases. But whenever I sit in with our labor and employment folks, their cases and situations are always eye-opening. So we now have the intersection between privacy law and employment law. I'm going to talk about a couple cases, but let me step back on a point. When we're talking about policies, we've talked a little bit about harassment being outside the four corners of the workplace. It's really important that employers have social media and online internet policies which set out that they may be monitored and that the repercussions that may result if there's negative impact on the employers or the company. The cases I'm going to talk about involve slightly different. So we've talked a little bit about statutes, criminal code. The cases I'm talking about are purely common law, which means we've got a right of action that exists outside any statutory breach. And they build on the concept. We're talking about privacy law, but really, in some ways, they're forms of harassment, or in some cases, stalking. The first case that we're talking about is intrusion on seclusion. And this is a bit of an older case, but it was a landmark case in Ontario. Many of you may know about it. This is where the invasion of a tort of invasion of privacy was officially recognized in Ontario. Of interest to this is that it imposes liability on not the company possibly, but also directors and officers and other employees. So this is something to consider. This is a situation where an employee who was the new partner of another employee was stalking, I'll use that word, it's not necessarily used in the case, but used her work, used her access at a bank to access the former partner's bank account information over 174 times.
I don't even access my account.
I know. So the court, finally grabbed hold of this and said, yeah, absolutely, there is this tort of intrusion on seclusion or privacy in Ontario. The standard, though, is that you have to intentionally intrude physically or otherwise on really the private affairs of an individual, and the intrusion would be highly offensive to a reasonable person, back to the objective standard. The flip side, so we do have this new tort. The flip side, or should provide comfort, is that the damage award that was set by the courts were relatively low. They put an upper cap for most instances at $20,000. Now, that doesn't mean that that will be the ultimate cap. If you can prove actual damages, it will be beyond that. But they're putting a general cap on damages that you can't prove up to $20,000. The next case I'm going to talk about is sort of the flip side. And how I want to tie this in, or want people to understand, is let's look at the last case was about intrusion on seclusion, meaning if you've got employees who are accessing information about other employees, that employee who's accessing it can be liable, but so can the employer. So we have to be careful about that. Now we're getting into the flip side of the privacy tort, which is public disclosure of private facts. This is a more recent decision. It is based, to Lorenzo's comments, on absolutely egregious facts. It is a revenge porn case, but the principles are the same. And this was a situation where someone in a trusted relationship received videos and photographs, who was in this relationship for several years, after convincing their partner to give up very personal, private videos and images of herself. He then uploaded it to a porn site where all of their neighbors and family and friends and everybody could see. So this was another historic case in that it recognized that now you've got the situation where if you're taking information which is inherently personal and putting it out there for other people to see, that you could be dinged. You could be held liable for that. Now, this case, the damages were likely going to be higher, but it was brought under the simplified procedure rules, so they were limited to $100,000, and that's what they were capped at. But I think the wording of the judgment was extremely strong, and if this is brought in through the regular court, we can expect the damage awards to be higher. Now, what I will say is that it was not a defended case. The defendant in this case didn't defend, and so it's under appeal right now. So we can expect that there may be some adjustment to the damage awards, but the principles and the arguments under the case, I think, are strong and are well reasoned. So I expect that it will still be a good law after that case.
And Paige, one of the issues for employers is, when you're trying to prove or get evidence of this, a lot of times on employers, it's on computers, so maybe you can talk about highlighting the importance of having a policy that allows the employer to kind of dig at that.
So let me I want to touch on 2 points just quickly. One, to your policy. As mentioned right at the beginning of this little segment, it's really important to have that social media policy and the acceptable use policy, where employees are aware that how they are and are not to use computer, the systems of the work environment, but also at home. If you go home and you want to rant over Facebook about one of your employees, or if you want to take, let's say, personal information about an employee, and post it on there because you're angry at the person, you're going to be held accountable. So your policies really need to sit this up front so that everybody understands the expectation. Okay? And the second thing I want to raise is on the investigation, where we get this concern about public disclosure of private facts is how much can you release to people, how much information can you release to people when you have information about sexual harassment or violence in the workplace. So you've really got to balance this issue of making sure you've got a safe work environment without disclosing too much information or to people who are not reasonably relevant to this environment. Or you can end up trying to do your best, but getting dinged on a privacy a breach for public disclosure of private facts, the tort. So you've got to really balance that. It's not easy.
And it's tough because the first thing that we get asked from an employer's perspective is, can we go into the computer and look at what they've been sending? And a lot of times the computers are company issued, and all the information is on the company server.
Yeah.
Right. But it gets more difficult where they have a personal phone.
Right. And it also gets more interesting if you've got Gmail accounts or web accessible email accounts that people are using in their work environment. So and we can discuss this another time, but generally let's leave the Gmail out. If it's a work computer, a work device, as long as you've got some policies in place, you can generally access them to take a look at what's going on. It's a little bit more complicated when you have a Gmail, a Rogers account or something like that. If it's password protected, it's really more challenging to be able to access and use that information. But what I will say is inevitably we get those screenshots, even when you think you've covered yourself, we get those screenshots that show what's happened. So please don't think that using something personal, using a personal email or using a private chat is going to exempt you from this. I can tell you 9 times out of 10, it comes back to haunt you, and we always, the evidence is always sent to us, and it's just damning when you're trying to either defend a case and it comes out that the person actually did what they're swearing up and down that they did.
Exactly.
All right, Lorenzo and Megan, I understand you're going to be addressing this final one, given that it's harassment yet again.
Yeah, we're back at it.
So this is a recent case where a decision of the Superior Court of Ontario found that harassment, including workplace harassment, can be a cause of action in its own right in Ontario. Now, sort of the distinction here from what we've been talking about before was under the Human Rights Code, you could found an action under the code for damages in the realm of the tribunal. This is now essentially a parallel form of proceeding that you could go through the court system to allege harm by the way of a tort.
And this case is interesting in that it, just to tie it back in, this is about the behavior that started outside the workplace and how it sort of flowed back into the workplace.
Definitely. It's again, a course of conduct that belittled or demeaned, an employee, and they brought a complaint to their employer, and, for whatever reason it wasn't dealt with appropriately, and the employer found itself at court dealing with this. So here you can see that, the employee alleged that the harassment damaged his reputation, impaired his career advancement, and caused him to suffer severe emotional distress, including depression, requiring him to miss significant periods of work. So if we go to the next slide, you can, just back a bit, you can see the test that the court came out with for this tort. There's 4 elements to it, and it essentially looks at the conduct of the defendants towards the plaintiff, whether it was really outrageous, whether it was intended to cause emotional stress, or whether there was reckless disregard for the fact that it was causing emotional distress, and whether the plaintiff suffered from, the outcomes of this, whether they suffered from extreme emotional distress. And finally, the 4th point, whether the conduct of the defendants actually caused the distress. It could be linked intimately to it. So in this case, the Superior Court found that the employee's experience of emotional distress was enough to satisfy the 4 elements of this tort, and they were awarded $100,000 in general damages. Now, it's a new tort in Ontario, so we're still seeing what will come of this and how it will be used. It's interesting because in Ontario, you can also sue for code damages in our court system as well. So I'm not sure if there'll be a separation or a distinction there, but there's now essentially a variety of ways that an employee can claim for forms of damages for conduct that they were forced to endure in the workplace.
Perfect, and that actually is a really important development in the law because it shows that things, because of the remedial legislation, are being expanded. The courts are looking at it and say, how do we provide protection to people who need it, to the vulnerable? And so here's the takeaway. Pure gold on this one, investigation and policy. You can put this one up in your office, right? And in the case of employers' obligations, right, what do you got to do? Well, I think we know this. We've heard it, but let's put a finer point on it. You've got to have policies. You've got to investigate, all right? This creates a little bit of a dilemma for employers because they look at it and say, well, does every complaint require an investigation? I cannot tell you how much time and money these can cost. Even on a run-of-the-mill complaint, all right, you got to bring in an investigator if you're doing that. It often takes a couple of weeks to get the investigator there, a couple of days to do the investigation, and a couple of weeks to write the report. What do you do with the employees, right? So you got to have a policy which actually applies to these situations. So have victim assistance available. Have a policy that deals with reporting. Have the investigation process set up. Despite the legislation, it doesn't mean you always have to hire a third party. Again, we need to do a triage. And have your policies and procedures in place that address each one of these elements. Address the issue of the investigation itself based on the complexity and severity of the harassment allegation. All right? Who carries that out will depend on the circumstances. Employers are running a bit scared right now, but the cost is becoming prohibitive, I can tell you. There are no cheap investigations anymore. And if you do them internally, right, you run the risk of somebody saying, that is a biased investigation because your HR department did it, and they've a vested interest in making sure that there's no liability to the corporation, right? So, what are the stages in a more complex investigation? Megan's going to talk to that. Oh, sorry. Go ahead, Megan.
Thanks, Lorenzo. And this should really be outlined in your policy and programs with respect to workplace harassment and violence. But essentially, for a complex investigation, this will involve a number of steps. Number one, reviewing the alleged details of the incident or the complaint. Meeting and interviewing the employee who's made the complaint, interviewing other parties who may have been witnesses, interviewing the party that's alleged to have conducted the inappropriate behavior. Again, then examining any other relevant documents and evidence, such as emails, notes, photos, videos, and then collating that all into a decision about what actually happened, whether the incident as described occurred and whether this constitutes workplace harassment. And then, in very complex cases, a detailed, lengthy written report summarizing the incident, the complaint, the steps taken during the investigation, all the evidence gathered, and any findings need to be put out in this report. The report findings have to be in writing, and it has to be, the substance of, the conclusions have to be shared with the complainant in this case. From there, it goes on to, a decision where you might want to contact your friendly labor and employment lawyers. But, if behavior is found to have been made out, then it becomes a question of discipline and how you, deal with the after effects of it.
Exactly. Thanks, Megan. And just to kind of wrap this up, and then we're going to take some questions. We're going to look at some questions, and we do try to answer what we can, and sometimes we may do a follow-up with respect to some that we can't. We have a number of questions here, and which shows you kind of how important this topic is. But in terms of what you got to do, all right, again, we boiled it down for you. Have appropriate procedures in place. Respond in a timely way. Don't let it sit. If it sits, it gets worse. Take the complaint seriously and have the adequate resources available to deal with it. It's the old commercial, pay me now or pay me later. If you try to skimp at the front end, it's going to cost you at the back end. We can tell you right now, and lawyers make their living off this stuff on both sides of it. So provide a healthy and supportive environment for the complainant. Don't do anything, don't prejudge. Don't say, oh, this one looks bad. We think that he or she is just making this up. Do it properly, do the triage. All right, let them know that they have rights.
And often, as the people dealing with this at a later date, in the context of a human rights complaint, the fact that you've conducted an investigation, have notes, and can point to a written report and conclusion will help you just further down the line. It goes to due diligence and protecting yourself. And
a point on here. So be quick, be confidential, be sensitive. All right, all at the front end. You can't always promise absolute confidentiality because you're going to have to bring the allegations, right, to the attention of the alleged harasser. And you may have to interview people about the harassment investigation. But you can actually have in the process the expectation that they will not spread the content of what they're being interviewed on. Right? That's very important. And when we are doing the investigation and you actually put that to the employee, all right, all of that should be in the context of an investigation. If they are significant investigations, one thing you may want to deal with from a privilege perspective is having your counsel retain the investigator, right? Then you at least have an argument of privilege because the counsel, right, your external counsel, there's some issues about internal counsel, whether that's privilege and what attaches, but your external counsel may be able to claim privilege on the report. And so not everybody can just say, I want a copy of it. Now, if you're going to rely on that, you may have to waive that privilege on what the. But from a front end, think about having the discussion with your counsel about conducting, retaining the investigator, and then the relationship is between the investigator and your lawyer, not between the investigator and you. Now, Let's get to some questions.
Thanks very much, Lorenzo. The first question is from an in-house solicitor with a municipal client. Please address the duty to take action or investigate in circumstances where no potential complainant will make a formal complaint, but the conduct is well known and witnessed by managers.
That's a really hard question. And I think it's hard because you're put in a spot.
Yep.
Right? The individual will not come forward. Now, I think the first step, and Megan, you can chime in on this as well, the first step is to say to the alleged complainant, is to say, look, we need your information to move this forward, right? Because that's critical in our ability to investigate. But it doesn't absolve you of the obligation to investigate if we've got kind of notorious behavior and conduct. We may need to do an interview anyway, bring what we have back to that person and say, look, we've done an investigation. We want you to kind of put this forward. If they don't, you can't force them. But if they're complaining and asking for damages, right, you can say, we need your help to do this. We can't verify, or it's going to impact the ability for us to investigate if you don't bring it forward. And that's going to actually help you defend against liability with the individual.
Yeah, and again, remember to what we said earlier about reprisal. It's easy to remind the employee about your obligations not to reprise, and that her complaint will be treated in a confidential manner as
Yes,
well.
that's important.
One of the questions we have about the whole issue of operating within a unionized environment goes as follows. In a unionized environment, if the allegations of harassment are substantiated, can the employer pay damages tax-free to avoid arbitration as a settlement?
So we do that all the time. I do a lot of labor arbitration cases. These cases are about 95% of the time settled. And you can actually, so the rules are this, and you hear about this all the time, even in wrongful dismissal cases. Can we attribute or allocate to general damages? Now, I think there's a lot of different discussion from a tax perspective, but I think you're in good position to say if there's an allegation of a breach of the Human Rights Code, there is a portion of those damages that can be allocated tax-free to general damages. But remember, we're in a closed system, so if an employer allocates and doesn't deduct, it still comes from somewhere, right? But the bottom line is it puts more money in the complainant's pocket because they're not getting taxed on those general damages. We would say this: be reasonable in what you attribute to general damages. Don't go crazy, because every plaintiff lawyer, every union lawyer will ask for the whole thing to be attributed. Be reasonable. Look at what the damage award might be, and secondly, make sure your documents indicate an allegation of human rights violation, so that if Revenue Canada wants to start poking around, you got a document which represents that.
Yeah,
right?
Agreed.
Very important.
And here's a question for Paige. From a social media and harassment perspective, is it expected that employers will be actively monitoring their employees' social media posts done outside of the work environment? Is it reasonable?
Oh, that's a great question. So let's split that into two. Are you expected to monitor your employees' outside social media accounts, let's say Twitter? I would say no, that you're not expected to monitor their employees' private social media accounts. But if something comes to your attention, you absolutely need to deal with it. The flip side is that we've seen is sometimes the employers have their own social media accounts that are used inappropriately, and they obviously do have an obligation and liability with respect to their own social media account that may be misused.
Thank you. And there are a series of questions from folks with respect to small companies. So let me just take one that seems to stand in for all of them. If you suspect one of your supervisors, or you know one of your supervisors, is having a relationship with an employee, and do you have a right to terminate with cause? Or, in a smaller company, can you transfer them in a place where it might be difficult or they end up with different hours?
Really good question, and a complicated answer. Let me try to boil it down for you. First of all, you're under an objective obligation to investigate if you think that there's a real concern. I don't think a relationship with a fellow employee is cause for termination, even with, you get a lot of American policies, where they have these relationship bars. I think that's a difficult thing to say is just cause under our law, but you can say to the individual, because these things happen when they blow up, when the relationship blows up. If there's conduct that is alleged, then you have to be really careful that you don't just transfer the complainant out and say, now you got to go because you can't work with this person anymore. Complicated issue, do the investigation, find out what the conduct is, make an objective assessment.
All right, thank you, Lorenzo, Megan, and Paige. And just wanted to remind everyone that there is yet another webinar on workplace law. Put in your calendars right now, please, April the 24th of this year. There will be another webinar on workplace wellness and mental health, emerging issues and effective management. Thank you to the almost 2,500 registrants for today's webinar. We appreciate you joining us for these educational systems. Bye-bye.